Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Normally, while we are teaching you, particularly in the IPC classes, we have been telling you that quality of evidence is essential, but not the quantity. So, the judge, no doubt, he will use his personal discretion, but basing on the material facts placed before him. And if he is satisfied that if one witness is able to depose properly, he is able to convince the court, yes, basing on his deposition, conviction can be given. So this is what is taught to you. And once again, the Honorable actually the Honorable Supreme Court of India gave a decision, of course, on 24/11/2021, maybe about 4 or 5 months back. Very good judgment. So somehow I traced it in Law Teller, so I wanted to tell you the same. So you can read the case as State of Rajasthan versus Bablu alias Om Prakash. State of Rajasthan versus Bablu alias Om Prakash in Criminal Appeal number 1475 by 2021, disposed on 24th November 2021. So please remember, so 3 judges, Uday Umesh Lalit, Justice Ravindra Bhatt, and Justice Neela Baini Trivedi, Madam. So all the 3 people held that even the version of a single witness is reliable. If it is found reliable or cogent, definitely it can form the basis for conviction. It can be the foundation for the ordering the conviction. This is what is held by 3 judges bench. Now let us go to the details of the case or facts of the case. So the facts of the case, this is a murder case, so straight murder case. So here on 8/3/2012, this incident happened in state of Rajasthan. On that day at about 2:30 p.m. when the complainant Sunil along with the deceased Rajendra, deceased and some others were in the house. Due to the civil disputes, the accused, number 1, Rajendra and 12 others, they came in a gory mob armed with deadly weapons and actually attacked the deceased person. So the deceased with and Dhanpal, the name of the deceased is Dhanpal, with weapons, and as a result of which he received injuries. Of course, Sunil and other witnesses were also there. Sunil tried to interfere, but he was threatened to the maximum. So he was given a life threat. As such, he could not be able to do anything and he whisked away from the scene of offense. No doubt, after the mob of 13 accused went away, then the injured, that is deceased Dhanpal, he was shifted to the nearby hospital where he suffered a lot and ultimately he succumbed to the injuries. So therefore, a case in crime number 75 by 2012 under sections 147, 148, 149, since they have trespassed in his house, 452, first 307, ultimately 302 IPC was registered. 13 accused, they have been arrested and the charge sheet has also been filed, right? So the trial court was convinced that actually it was convinced on the point of section 149, that is common object, and therefore it has convicted all the 13 accused. Of course, do they keep quiet? No. They have gone in appeal. The Honorable High Court of Rajasthan, yes, they have considered the evidence against A1 and A3, A2 and A3, and convicted them to life imprisonment, whereas they were not convinced with the evidence against the other accused. They thought that it is a tutored witness, tutored evidence, or parrot-like version. So therefore, they have acquitted the other 11 accused. Only 2 accused were convicted by the Honorable High Court of Rajasthan. Agreed by this, the state of Rajasthan, so that is the police department, they appealed against this before Honorable Supreme Court of India. Here, Honorable Supreme Court of India, they have appreciated the evidence of PW 25 Roop Singh. So His evidence was to the point. He was subjected to thorough cross-examination by 6 defense advocates, but he withstood all the cross-examination and he deposed the same version without any defect. Luckily, this was corroborated by the 2 other witnesses also. Therefore, it is cogent and well-supported version, and therefore, even though so many other witnesses they turned hostile and they did not speak against all the accused, the evidence of Rup Singh has become the pillar stone. It has given the it has stood as the order for giving conviction. Now the Supreme Court is convinced that all the accused have committed the offence, because no doubt the other accused, only some A2 and A3, they stabbed him or they attacked him with the axes or something. But the other accused, because of their presence, since they were present, since there is a deep-rooted enmity, since there was civil dispute pending them, all of them have got the common object. So therefore, all of them are liable for punishment. So it has reversed the judgment of the Honorable High Court of Rajasthan and convicted A1 to A13. Here, the most important point you have learned is, no doubt 100 witnesses may give parrot-like version on one point, but if a single witness tells the true facts, if the court is convinced that he is telling truth, basing on his statement, the verdict can be altered from acquittal to conviction. This is what is happened in this particular case. Therefore, so to conclude, I want to tell you the quality of the evidence is only essential, but not the quantity. So please read the judgment and enrich your legal knowledge. Thank you very much.